Okay, so welcome everyone to this CRPD course. And the first lecture is a general one on human rights, international law, and the CRPD. And this is especially for people who are coming to this without any familiarity with international law or the CRPD, or without much familiarity. For some people, if you're human rights lawyers or activists already, a great deal of what I'm saying is going to be familiar to you, and I invite you to just reflect on the theme and what I'm saying based on your own knowledge and experience. So, well, I'm going to do this a little differently. There. Okay. So we're going to start with just some course housekeeping. Welcome. I would like to remind everyone that you can keep checking in with me about how you're finding the reading and assignments. Some of you are already letting me know that you've been working on the reading and assignment, how it's working for you to be in the lectures, to listen and see how you want to participate. So just remember, feedback is always welcome. And as I've said, questions are welcome. It's easiest for me. It seems to work best if you use the chat function. And then periodically, I will be checking it. Actually, in this software, it's easy for me to see the chat at the same time as seeing what I'm sharing on the screen. So that should work well. And if a person isn't really comfortable writing and you would rather ask your question by speaking, just write in the chat, I would like to speak. I would like to ask something speaking. Okay, so to start off, what are human rights? Where do human rights come from? Some of us maybe grow up with the concept of human rights, or we're introduced to the concept of human rights very early on in life or in school. We grow up in a culture where people around us care a lot about human rights, maybe protest and demonstrate in support of human rights, and take other actions. In some countries, some of us might have been freedom fighters and and activists in very significant movements. And in other countries, and for some other people, you might really not have much of an idea about human rights, or have a sense that you as a human being are entitled to have rights, that there's something recognized by the international community, by millions and billions of people throughout the world, that says each one of us is entitled to certain basic respect and freedoms, and to, at least within the human community, to be nurtured and to have some standard of living and ability to meet our basic needs. And so for many people, the idea that you have human rights it can be revolutionary once you understand, I have human rights. I don't have to be abused. I don't have to be subordinated. I don't have to be in degrading situations. That's not the way it's supposed to be. And I can fight together with other people to change these situations that are violating my human rights. Now, then you have to we can ask, well, what are the human rights? What are human rights? How do I know what my human rights are, and where do my human rights come from? And there's a few different answers to that, because human rights come from people's experiences of injustice, which in a sense happens on the individual level, but the development of human rights, the development of the idea of human rights, and some articulation of what those rights are has been happening on a collective level and on an international level. Um, some people would identify it as starting with the Universal Declaration of Rights, but really it's been going on for a lot longer. And there are different traditions in different regions of the world that have had different kinds of basic views about human rights, that each human being has a worth and dignity in themselves and is entitled to certain basic respect, and to be able to have their needs met. And different cultures and societies may have different ways of talking about this. It may be more in terms of duties, in terms of the ways that human beings should be treating one another, and other cultures might frame it more in terms of rights that you're entitled to claim against another person or against the state. So there has been an ongoing conversation that's framed in terms of international human rights standards through the United Nations, beginning with the Universal Declaration of Human Rights, abbreviated as the UDHR. That was developed in the period following the Second World War, or the war in Europe and the war in Asia and the Pacific. And international society was very moved by the massive human rights violations that happened in the course of those wars, including violations by governments against their own citizens. Of course, we know also that that wasn't the first instance of widespread and massive human rights violations. There had already been a massive international movement against slavery and the slave trade, and in some sense that was really a first recognition that there should be international law that would cover human rights and protect protect human beings against human rights violations, in the sense of recognizing that there was this massive injustice against human beings, that no person should be treated that way, and that governments were obligated to end those practices. But the UDHR is generally considered to be the first attempt to it's the basic document in international law, in international human rights, that attempts to set out a list of human rights. I don't have a link to it in this presentation, but you have that in your reading materials. I invite you to familiarize yourself if you aren't already familiar with it. It's a very good basic statement that invites you to reflect on, how are you doing with your human rights? Have you experienced violations of these rights? How are you working for these rights to be implemented in practice for everyone in the world, or for people in your community? So the Universal Declaration is a declaration by the United Nations. It's not a treaty. And we'll discuss a little bit about the difference between a declaration and a treaty. A declaration is something that UN member states or the member states of any international intergovernmental organization set out to articulate certain commitments they want to make, certain principles and standards they want to recognize, it is not actually legally binding on them within the framework of international law. So, from the Universal Declaration, the United Nations started to make various treaties on human rights in order that governments should be legally bound to respect and uphold these human rights that are being recognized, and to clarify what their obligations were. And you will see, you have in your reading materials the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social, and Cultural Rights, and these are some of the basic ones. You'll see other treaties, the Convention on the Elimination of All Forms of Discrimination Against Women, and others that are considered thematic human rights treaties dealing with one theme at a time or more. Excuse me just a second. Okay. Out now. Get out. Excuse me. There was some disturbance going on here that I just had to deal with. So, what is the role of civil society in creating, asserting, and enforcing human rights? Because you've heard me saying that it's member states of the United Nations. The United Nations is made up of governments, and so it's formally always governments that are negotiating treaties, that are making these declarations in the United Nations, and governments are the ones that are legally obligated with respect to human rights treaties and other obligations under international law. Civil society, meaning all of us who are not government officials, all of our organizations, our activists, our advocates, our freedom fighters, civil society has always had a huge role in creating human rights, in being in taking part in discussions about human rights, advocating, conceptualizing what the injustices are and what we actually need, to have our human rights implemented. Okay, you're not hearing okay. I'm seeing that people are not hearing. Is it still that you're not hearing? Because my microphone says it's okay. Let's see. Are others able to hear me or not? Is anyone able to hear now? It doesn't sound like anyone's able to hear. You can hear Jillian, okay. Is anyone else able to hear me? Okay, so I think maybe hopefully the audio issues are resolved, if that is okay. And I'm going to continue. I think I'm going to continue. At least two of you are able to hear me, and if others can't, then I'm going to hope that it's all being well recorded and that we can work it out that way. I'll just write one more message. Okay, apologies for the interruption. Okay, so we're just saying about the role of civil society in creating, asserting, and enforcing human rights. Civil society, as many of you know, has an ongoing role. We were involved in creating the Convention on the Rights of Persons with Disabilities together with the government representatives. We are the ones promoting it, promoting implementation, campaigning for our rights. We are the ones going to Geneva and making shadow reports to tell the United Nations human rights mechanisms about human rights violations that they should be recommending countries to remedy. So there's an ongoing, very significant role of civil society, despite the fact that it's formally governments that are the ones having human rights obligations under these treaties. I'm going to talk a little bit about the CRPD as a human rights treaty. What is the meaning of signature, ratification, and accession? So some of you are living in countries that are states parties to the CRPD. That means your country has ratified or acceded to the treaty. It's legally bound. It is legally obligated under international law to uphold all of the obligations contained in the convention. A government can sign a treaty. Typically, the treaties are first opened for signature, and a number of governments will sign, which indicates an intent to become legally bound to go through the process of ratification and deposit a formal ratification with the UN. Accession may be when a country did not participate in the signature, but has decided to become legally bound at a later time. And essentially, ratification and accession are equivalent under international law. Both of them mean that the country is legally bound. But if your country has signed and not ratified, the country is not legally bound in international law to comply with the convention. It is only bound to not undermine it. So the United States is a country that has signed but not ratified the CRPD. And so if this is the case for you, you should be just careful to understand that your country is supposed to be upholding the CRPD in principle. It's not supposed to undermine the right, but it is not formally bound in the way that countries are that have already ratified. And we'll talk later on and in subsequent classes about how different countries actually treat their obligations under international law, how seriously they may take them or not. And much of what actually happens on the ground is a matter of the political culture and the particular legal traditions of a country in terms of how the country views its international law obligations. I am sorry. I was thinking that you are seeing the slides. Are you seeing now the slide that says CRPD is Human Rights Treaty? Or are you only seeing, you can answer me in the chat, or are you only seeing, you're not? Well, okay, I don't know. That's too bad. Thanks for letting me know that. Let me see if I am doing the main screen, if that's going to work better. Are you seeing it now? The slide that says CRPD is Human Rights Treaty? Okay, there we go. I don't know why it wasn't working the other way. And that's the previous slide. What are human rights? So I'm glad we've got that worked out now. Okay, so the next thing to address is, what is the optional protocol? Many treaties have optional protocols of one kind or another. We're talking here about the optional protocol to the CRPD. An optional protocol is an associated treaty. It's a treaty that governments sign that goes together with a main treaty and contains optional obligations that the countries may undertake or not when they are also ratifying or acceding to the main treaty. So the CRPD optional protocol contains obligations for the state to accept a complaints procedure and an inquiry procedure where individuals can submit a complaint that their human rights are being violated by the country to this Committee on the Rights of Persons with Disabilities, and the committee will issue a public written statement of its views as to whether human rights violations have taken place, what the violations are, which provisions of the treaty have been violated, and what the government is obligated to do in order to remedy those violations. So let's take a look at the Committee on the Rights of Persons with Disabilities. We can go to that website. And what is the Committee on the Rights of Persons with Disabilities, and how does it work? Committee on the Rights of Persons with Disabilities, I can read from this, is a body of independent experts which monitors implementation of the convention by the states parties. All states parties are obliged to submit regular reports on how the rights are being implemented. And as we said, the optional protocol gives the committee competence to examine individual complaints with regard to alleged violations of the convention by states parties. So if your country is not a state party to the convention, you cannot make a complaint under the optional protocol. If your country is a state party to the convention, but not a state party to the protocol, you also, the country is legally bound by the convention, but unless they have also ratified the protocol, you would not be able to make a complaint. So we have this map of ratification, and we'll see if we can access that. Maybe it's not going to work, but yeah, okay, it's coming. We can see, no, it just gave us the general ratification status, but we can see countries that, okay, this is only saying with respect to the convention, not the optional protocol. Most of the countries appear in dark blue, and they're the ones that have ratified the convention. Countries that appear in light blue are the ones that have signed the convention but not ratified. And the countries that appear in orange are the ones that have taken no action, I believe. Yes. So as you can see, most of the countries in the world are states parties to the convention, and there would be a similar. Okay, here's the one on the optional protocol. As you can see, there's a lot fewer countries that have ratified the optional protocol. Almost all of Latin America, a number of African countries, a number of European countries, and a few countries in Asia and the Pacific. So it's good to get to know if your country has ratified the protocol, and then you would be able to make complaints of international of violations of the convention, of your individual rights under the convention. Now, talking about the committee, there's a great deal. What does it mean to have a body of independent experts to monitor implementation? They do review the reports by states parties. That's one of their primary obligations. They conduct a dialogue with the states. That they spend probably the bulk of their time when they meet having these dialogues with states parties, which are public, meeting with NGOs, non-governmental organizations, about their views of the situation in the state party. And they also are spending their time dealing with individual complaints. Those are in private meetings. And they're empowered to issue general statements to interpret the convention and clarify the obligations on states parties. Most of those are classified as general comments, and we will be talking about general comment number one quite a bit. General comment number one is the comment on Article 12, equal recognition before the law, on legal capacity. You'll see here they've adopted 4 general comments so far, and they're still considering the fifth. They're in process of working on the 5th one, on right to independent living, and the committee is planning to keep on addressing particular issues. First, they will have a day of general discussion, and then they will start working on a general comment. So the next one, I believe it's next week, is going to be on, they're having a day of discussion on Article 5, equality and non-discrimination, and they will proceed to draft a general comment on equality and non-discrimination following that. Civil society, non-governmental organizations, academics, activists can participate in these days of general discussion and can attend the meetings of the committee. There's a lot of information about on this website of the committee about how, you'll see here an information note about how organizations of persons with disabilities and others can participate in the upcoming meeting. And I would just invite you generally to explore this website, that you have the basic documents, the work of the committee. Here's key documents related to the reporting cycles. You can find all of the concluding observations here. So if your country was reviewed by the committee following these reviews puts out a set of concluding observations, which is a set of findings and recommendations about in which way the government may be doing well and which ways they are not yet meeting their obligations under the convention, and with recommendations about what actions they have to take. So you see here the first one that shows up is on Moldova, and it's generally in reverse chronology. So there you can click on the link and you can download the concluding observations on Moldova in any of the official UN languages. And I would invite you to find out if your country has ratified. I'm sorry, not if your country has ratified. If your country has ratified, if they have been reviewed by the committee. Another way to access all those documentations is to go to sessions where they show future sessions. These are countries whose reviews have not yet been scheduled. Then you'll see the countries that are up for review in this meeting that's coming up now. States, I believe some of them, in some cases, they show it incorrectly. So the pre-sessional working group is to develop lists of issues. But the meeting that's going on right now, you see that they are going to be reviewing the reports of Latvia, Luxembourg, Montenegro, Morocco, Panama, and the UK, and they're developing lists of issues prior to reporting for Argentina, Australia, Ecuador, and Tunisia. That's in the second round of reporting. So when you go there, I'll go to an earlier one where the full, where everything would already be there. This is for last September's. You'll see the general documentation, the agenda, program of work, announcement by the CRPD chairperson, and then you have all the materials for every country that was reviewed. So you have the state parties report, the list of issues. After the state parties report, the committee will set out a list of issues with questions and requests for additional information. The state parties reply. Information from civil society organizations. Sometimes there's a large number of reports or submissions from civil society, sometimes only a few. Then there's more information submitted just before the session or for the list of issues. And then the last document, once it has actually happened, is the concluding observations. And it's always useful. This page on sessions is useful if you want to see everything related to the review of a particular state party. You see all the materials there in one place, and you can also always go to the page on concluding observations or the page on state parties reports or list of issues or applies to the list of issues if you're specifically interested in that. I think there's quite a lot more here, and you'll see some resources, publications, general publications on guidelines for implementing the convention put out by the Office of the High Commissioner for Human Rights, materials on reporting guidelines and simplified reporting procedure. They made a set of new guidelines that's useful. I think I'm not going to go into all of this. We're going to have another class later on. I believe we can cover some of these things more in the sessions 7 and 8 when we're going into more detail about the process of how the committee works and what are the interactive ways that people can advocate for and participate in implementation at the domestic level, and how they can also participate in the national monitoring and the international monitoring. So I'll just point these out, that there are these set of guidelines on the reporting process and on the standards that the committee uses to review the reports. There's information on the complaints procedure under the optional protocol and the inquiry procedure and many other things that you can see here. Secretariat contact details, how to direct complaints to the treaty bodies. So generally, it's good to familiarize yourself with this website. I have this, I'm pretty sure, linked in the general materials web page for the course, and I very much invite you to familiarize yourself with what the committee is doing and what they can do. And if people are interested right now, you can follow the session of the CRPD committee that started yesterday. There are live streams. There's webcasts that you can follow, and here's captioning, and here's apparently the webcasting links, and it's something, if you're interested, if you'd like to get to know how the committee works and observe it, it's possible to do it now. Oh, look at that. See, I'm not familiar with this particular technology. It's a little bit new. And I don't know how that's working, but apparently there is this way to view it on the internet, on the webcast, and apparently it's possible to participate, according to this, by the webcast. So we're going to go back here now, and I'll go back to the slides, and we're going to look at the convention. And I'm sure that many of you are already familiar with the convention, but we're going to give a general overview of the overall structure and what the rights are that are contained in the convention. So let me see actually how I was doing it in the slides, and no. Okay. All right, I'll just do it that way. Do it that way is better. No apologies. Okay. Just working out the technology here. Okay. So, Convention on the Rights of Persons with Disabilities. There's many websites where you can find a copy of the convention. Some of them are PDF. This one I like because it's HTML and you can go to specific articles that you want to focus on. So the overall structure, we have Article 1. We have Articles 1 through 4 as general obligations. As general materials about the convention, Articles 5 through 9 as I would say they're specific obligations, possibly specific rights, transversal in that, say, there's a right to equality and non-discrimination and many obligations, but it's not necessarily, it's in a sense it's a right, but maybe it's a general right rather than a specific right. Similarly, women with disabilities are entitled to be treated equally as men with disabilities and to be treated equally as women or men without disabilities. And there are specific obligations in relation to that, but it's not a specific human right that's such as, for instance, liberty and security of the person. It's general. It's with respect to all the human rights. So first you had the general statements about how the entire general obligations governing the entire convention and all of the rights, and then you have some specific obligations um, governing all of the rights. You have Articles 10 through 30 are the specific guarantees of rights, from the right to life through participation in cultural life, recreation, leisure, and sport. Then you have some additional general obligations: statistics and data collection, international cooperation, national implementation and monitoring. Those are all, I would say, specific obligations at the national or domestic level. Then you have the obligations and mandate of the Committee on the Rights of Persons with Disabilities and various aspects of its relationship with states parties. Then you have Conference of States Parties, which relates to the committee elections, but also functions as a conference as an annual conference where states parties and civil society and any interested participants can get together, and it's an actual substantive conference to discuss matters related to implementation, which can be anything that's related to the convention, to the obligations and the rights in the convention. We can talk a little bit more about the Conference of States Parties. Some of you may already be aware of it. It's a space where you can find out about different projects that are going on, campaigns, advocacy, law reform in relation to, say, Article 12 on legal capacity or Article 19 on living independently and being included in the community, or anything else you may be interested in. And you can also hold your own side events to inform others about work that you're doing in any area related to the convention. Then there are these other provisions that are essentially formal provisions related to CRPD as a treaty: depository, signature, consent, entry into force, etc. I'm going to discuss a little bit about the content article, the substantive articles of rights and obligations, and let's see what preamble is worth paying attention to. It states some of the concerns and justice issues that are the motivation for why the convention is being adopted. The purpose, I would draw attention to the purpose: to ensure the full and equal enjoyment of all human rights and fundamental freedoms by all persons with disabilities. I like to call attention to that because states will sometimes resist including people with psychosocial disabilities, and that's contrary to the purpose of the convention, which means it's the states in international law, states should always be adhering to the purpose of the treaty and implementing it in good faith, and they are obligating themselves to ensure the full and equal enjoyment of all human rights and fundamental freedoms by all persons with disabilities. So there's no justification for them to say, we're not going to implement Articles 12 and 14. We're not going to include people with psychosocial disabilities. We're going to give them an inferior legal capacity. That's actually contrary to the purpose, as well as being contrary to the specific articles that they might be resisting. Then you have definitions, and I know I don't have time to do everything in detail the way we're planning this, but I'm going to invite you to read, to review as much as you can and ask questions. The definition of discrimination on the basis of disability is significant. It's very comprehensive, and any distinction, exclusion, or restriction on the basis of disability which has the purpose or effect of impairing or nullifying the recognition, enjoyment, or exercise on an equal basis with others of all human rights, etc. So it includes purpose and effect. A state cannot say, well, yes, it had this provision has the effect of excluding people with psychosocial disabilities, but that wasn't our intent, so it's not a violation. No, if it has that effect, or contrarily, if they decided they actually want to exclude people with psychosocial disabilities, but they are trying to frame the legislation in a way that doesn't make it explicit what they're doing, that too is contrary to the convention. So general obligations include some important provisions about modifying and repealing legislation that is discriminatory. And I think I'm just going to go through the list of rights now. The list of the specific ones. So we talked about, general principles I'll call attention to as well, especially respect for inherent dignity, individual autonomy, including the freedom to make one's own choices, and independence of persons. That's very significant. That informs and supports the right to legal capacity, which is very significant for people with psychosocial disabilities. Non-discrimination, full and effective participation and inclusion, respect for difference and acceptance of persons with disabilities as part of human diversity and humanity. So we don't have to be all the same as human beings in order for everyone to have their human rights respected. If people think that we're different than them, it doesn't give them an excuse to disrespect our human rights. It doesn't give the state an excuse to create some inferior treatment and say that that is because we're different from other people. The acceptance of and respect for difference means that our differences mean that we might sometimes need accommodation, or we might sometimes need support, but it's never justified to take away the person's freedom or take away the person's autonomy on the basis that they're different. You can never take something away from somebody because they're different, and you can never, it's not justified to say, well, to try and impose your judgment on another person because you think you know what's best for them. So it's always, respecting difference and accepting people in their diversity means you also accept their autonomy to decide what's actually best for them and what they need, and how, what they actually need in relation to the ways that they, or how to negotiate the ways in which our differences mean that we should treat each other in some way with accommodation. So you have women with disabilities, obligations related to the rights of children with disabilities, awareness raising, obligations, accessibility. Well, maybe I'll say something about children with disabilities. Also, one thing that we considered important was states parties shall ensure children with disabilities have the right to express their views freely on all matters affecting them, their views being given due weight in accordance with their age and maturity on an equal basis with other children, and to be provided with disability and age-appropriate assistance to realize that right. That is, for children, the way that states have to provide for children to be accepted in their rights related to decision making, even though children don't have the same rights as adults to exercise full autonomy in their lives. We have awareness raising obligations, accessibility, right to life. And now I think I am just going to go through them so I can get to another part of the presentation. And I invite you to really explore all of these articles that interest you. The specific rights, we have right to life, situations of risk and humanitarian emergencies, equal recognition before the law, which we will talk about in detail in another class, access to justice, liberty and security of the person. We'll also talk about that in detail. Freedom from torture or cruel, inhuman, or degrading treatment or punishment. Freedom from exploitation, violence, and abuse, protecting the integrity of the person. Those three all go together in most respects, and we'll talk about that in the next class. Liberty of movement and nationality, living independently and being included in the community. That will also be another class. Personal mobility, freedom of expression and opinion, and access to information, respect for privacy, respect for, that's supposed to be the home and the family, education, health. That health is important in many respects, but for us, especially because it recognizes the right to free and informed consent. Habilitation and rehabilitation, work and employment, adequate standard of living and social protection, participation in political and public life, and participation in cultural life, recreation, leisure, and sport. So you'll see some of these rights might be classified as civil rights or political rights or economic, social, or cultural rights. And the convention puts all of them together. It doesn't say that one kind of right is more important than another kind of right. And I think we all are aware from our experience in reality, you can't, if you're not having an adequate standard of living, it's going to be very difficult for you to exercise choice in your life, to choose where and with whom to live, to freely exercise your legal capacity, and to freely choose your work and employment. It makes you very vulnerable to being exploited by others, to being the victim of violence and abuse by other individuals and also by the state. And so we need to make sure everyone has an adequate standard of living and social protection. And that right is really interdependent with other rights like liberty and security and equal recognition before the law. At the same time, if you're not free, if you are locked up in a psychiatric institution, that has a serious effect on your adequate standard of living and social protection. You might have lost your home, you might lose your job, you're not able to go out and earn a living for yourself, you're not able to, and it can impact, and certainly while you're in the institution, even if they might be feeding you and sheltering you, that is not an adequate standard of living for a human being, and it should never be considered that keeping people imprisoned is a way of meeting their basic needs. So this is somewhat an off the cuff approach to just giving certain examples of some of the relationship between rights, but we'll be able to look at that more differently. I would invite you to bring in those kind of considerations at any time, because it's recognized in the human rights field that all human rights are interdependent and interconnected. Also, that all human rights are universal, that a state, some states actually would say, well, we recognize economic, social, and cultural rights, but we don't think that those, that say equal recognition or liberty and security of the person are really human rights. We're just going to recognize the right to health, the right to work, the right to an adequate standard of living. And other states do the opposite. Other states will say we recognize the right to access to justice, liberty and security of the person, participation in political and public life, but we just don't really think that people have a right to an adequate standard of living. It's purely the government's charity that that decides whether we're going to give people income assistance or food assistance to meet their basic needs. And there is a general human rights principle that's been recognized by the official document, or it was recognized in a Vienna conference, 1993 Vienna Conference on Human Rights, that in fact all the rights are universal and all the rights are, and that the rights are interdependent with each other. So, sometimes we will have these debates or implicit disagreements where certain states are not, say certain states might not really deal with adequately some of their CRPD obligations based on that kind of approach, where they don't want to recognize certain rights but only others. And okay, I think we've covered a number of these things. I'm going to invite you to look at this page, look at whatever version of the convention you most prefer to use, and familiarize yourself with the full range of human rights that are protected, because people with psychosocial disabilities have the right to enjoy all of these rights. And sometimes we might focus narrowly on certain rights that we decide to highlight because they have been the primary, or they're in a sense a cutting edge way that our rights have been violated, they're somehow definitive of the way our rights have been violated, such as equal recognition before the law and equal legal capacity, or liberty and security of the person, where it's been really definitive that the ways that societies violate the human rights of people with psychosocial disabilities always includes deprivation of autonomy and deprivation of liberty in one way or another. And so focusing on those human rights in this course is a way of, you know, really tackling aspects of what we've called the paradigm shift in the CRPD, specifically as it affects people with psychosocial disabilities, and as people with psychosocial disabilities worked on creating it. And at the same time, we have to always keep in mind the full range of human rights that we're entitled to, and just make sure that we don't forget the rest of them, so that we can call on any of them as needed, and people can make complaints under the optional protocol or address in their shadow reports any of these rights according to how, what is going on in the particular situation. So, the optional protocol. We've discussed a little bit about the optional protocol. I'll just show that here now. And we discussed that it has both an individual complaint procedure in Articles 3 through 5, and then an inquiry procedure in relation to grave or systematic violations of rights by a state party. So I would just like you to be aware of that for now. And I'm going to talk a little bit about the CRPD drafting and negotiations. As some of you know, I participated in the drafting and negotiations. And for me, the best way to describe it was as something analogous to a constitutional moment, or as a type of constitutional moment. So constitutional moment refers to in when a country is newly creating a constitution, they're deciding what their form of political organization is going to be, how the government is going to work, and they're also deciding what's going to be the relationship between the state and citizens, what rights people are going to have. It's a kind of watershed moment where people are coming together to really reflect on how they're going to create a document that governs how they're going to live together going forward, how they're going to relate together, how they're going to resolve differences, what are going to be the rights and principles and duties, and what are the values that are going to inform their social and political organization as a country. Now, it's that same spirit of people coming together and deliberating and reflecting, how do we want the rights of people with disabilities to be recognized? What are the situations we're responding to? What are the values that we're upholding? What are the principles? What is the vision that we have for how states should be providing for people with disabilities under their laws, under their programs and policies? And So what is the vision of the rights that we see people with disabilities having and the obligations that governments have towards people with disabilities? It was a process that took place over a period of about 4 years, from 2002 through 2006. There were 9 meetings, 8 sessions of the ad hoc committee. Has a longer name. Ad hoc committee on the has a longer name because the proposed name of the convention was longer to begin with, but we call it the ad hoc committee for short, in which the convention negotiations were taking place. There were 8 meetings of the ad hoc committee, and there was a meeting of a working group of experts that were chosen by states and by civil society organizations that produced a draft text of the convention out of all the variety of proposals, text proposals, proposals of, vision and principles that were received. I participated in that working group as a representative of the World Network of Civil Society, the World Network of Users and Survivors of Psychiatry. And there were many aspects of that process that made it conducive for the perspective of the World Network to actually be incorporated and accepted into international law. I'm going to share here the negotiation archives. And you'll see when you look at the PowerPoint yourself, which it's the same essentially as the one I already have on the course website that was used in the spring. You can go to this website, and I have actually a great deal of these materials in the, maybe I should go to that page also. I have a great deal of these materials in the page for the course, the page on general materials. This is a truly fabulous resource if you want to research anything about the history of the drafting and negotiations of the convention, how certain provisions came to be, how something got put into the convention or left out of the convention. This can be important in advocating for a certain interpretation, advocating that, for instance, that Article 14 prohibits involuntary hospitalization and institutionalization. There's information that the CRPD committee has used about proposals that were rejected in the ad hoc committee that would have actually called that into question. So the fact that it's very useful to take a look at what was going on at that time, the different materials, the revisions and amendments that were proposed. But that's all significant if you're interested in doing research in relation to the history of the drafting, or also if you're interested in, especially in the community of users and survivors of psychiatry activists. Some people have asked, how did we get the convention? Is it some some kind of a top-down thing that governments or academics wrote that really has nothing to do with us. And when you go to the negotiation archives, you can see that that's absolutely not true. That's part of what I was saying from my experience as a member of that drafting group in 2004, and as a representative of World Network throughout the negotiations. We ended up having a group of about 15 people from the World Network and its member organizations that came to the UN and participated in this process at different times, at different ones of the meetings. So here is a page about the working group. You'll see the membership. There were 27 governments from different regions, and there were these non-governmental organizations. We had organized ourselves as a disability caucus, as the International Disability Caucus. And it was organized on the basis of the leadership of DPOs, disabled people's organizations. It was open to all DPOs and their allies. And the governments in the UN, in the second session of the ad hoc committee, when they were trying to decide, in the second session, they had decided, yes, we are going to go ahead and create a convention. And sorry, I see someone is asking for a link. This is a link for the page I'm on right now. And I'll give a link for the negotiation archives as a whole a little bit later. It's also on the course page, and I'll show that also. So, yeah, we had organized in an international disability caucus, and in the second session of the ad hoc committee in 2003, governments were deciding that yes, they are going to go ahead and draft a convention and adopt a convention, and how are we going to decide on the content of it? Well, some countries had already made proposals, some NGOs had already made proposals of text, and they decided that the process would be a working group composed of representatives of government and of non-governmental organizations. It was interesting because at first there were discussions that either wanted to leave it to academics to create a drafting group of academics, or to simply start discussions in the plenary of the ad hoc committee by all the governments that were present and had some proposals. And the NGOs didn't like either of those proposals. We felt that it left us out, and the NGOs being particularly the disabled people's organizations, and many governments didn't really like that either, because there were only a couple of governments that had produced a full text. Mexico was the main one, and governments wanted the chance to really participate in working on a text themselves and not just negotiate something someone else had already drafted. So this proposal was to create a group, a smaller drafting group that was representative of the different regions, so that, it was all chosen proportionately, and the governmental regions chose their representatives. And for civil society, they approached the International Disability Caucus, and there were seven international disabled people's organizations, of which WNUSP was one, but there were many there were some national and regional groups of people with disabilities that felt the international organizations didn't necessarily represent their regional perspectives. So we also developed 5 regional groupings, and each of those had a representative on this drafting group. So you'll see there some of the representatives were essentially representing the disabled people's organizations in their region, and others were representing a specific disability constituency or the cross-disability constituency. And so we had both of those dimensions reflected, and there was a very strong principle that the specific disability groups, or as some would say, the specific impairment groups, but I have issues with the term impairment used to describe psychosocial disability, but some people would say the specific impairment groups. It was recognized that we were all speaking for ourselves, that we had unique perspectives that needed to all be considered on an equal basis with each other in terms of drafting the convention. And that was very important as a way of ensuring that the views of users and survivors of psychiatry about what is violating our human rights, and the fact that certain practices that are commonly accepted and taken for granted, like the deprivation of legal capacity and the deprivation of liberty in institutions, are actually human rights violations. And my approach as the person who drafted much of the advocacy of the World Network and the text proposals was to frame all of our human rights issues in terms of, this is an instance of discrimination in the exercise of a fundamental human right. So I'm not sure, well, I have it in the course page maybe. Yeah, I was actually going to that earlier. I wanted to draw attention to the document from the World Network of Users and Survivors of Psychiatry that we brought to the first meeting in Mexico City. This was even prior to any of the official meetings at the United Nations. Let's see if that's going to give me just a document. I guess it's giving me a document. The government of Mexico, which had taken the initiative overall to in this process of creating a convention on the rights of persons with disabilities, decided to convene disabled people's organizations and academics to convene civil society experts prior to the first meeting at the UN in 2002. And WNUSP was able to attend, and we sent a statement. So I would encourage people to read this if you're interested in this aspect of the history. And as I was saying, the way that I framed the issues was to position ourselves, to position the violations that affected us as instances of discrimination against people with disabilities, discrimination based on disability in relation to the exercise of particular human rights. So here on incarceration, or forced hospitalization, forced institutionalization. Let's see. We do not believe that incarceration is ever justified when imposed on a discriminatory basis, such as psychiatric civil commitment, which can be imposed on people who are considered dangerous to the community, but only if they are diagnosed with a mental illness or mental disorder. So that was one of the first ways that we were that was a very initial step in putting these issues out to the group of NGOs that were gathered at that meeting. That group accepted our advocacy and incorporated our issues into the paper that was put out by, let's see, I don't have it here, but there was a paper that came out of that meeting that was representing the NGOs, and it included the issues identified by the World Network. That was very significant as an initial step. And there's many ways of speaking about different aspects of that history. That paper called "What Rights Should Be Included in a New Convention." That paper was the listing of rights by NGOs in that paper became the basis for the discussions in the first meetings of the ad hoc committee. So even though it wasn't addressing the content of what we identified in relation to specific rights, it was an important recognition of the leadership of disabled people's organizations that I think empowered us and helped us to take the next steps. We had the opportunity to speak out in those meetings. Then we had the opportunity to submit text proposals. And here you can see when we were developing text proposals, framing it even more clearly and directly in international human rights law language. So here on the right to liberty, no person shall be detained, interned, or confined involuntarily on account of actual or perceived disability. And just taking that as one example, and here on freedom from torture, everyone has the right not to be subjected to forced or coerced interventions of a medical nature or otherwise, aimed at correcting, improving, or alleviating any actual or perceived impairment. And where is autonomy and self-determination? Here, right to recognition everywhere as a person before the law. Everyone, including all persons with disabilities, has the right to recognition everywhere as a person before the law with full legal capacity. Persons with disabilities who experience difficulty in asserting their rights, understanding information presented to them, or articulating or communicating their choices have a right to be provided with advocacy assistance and other reasonable accommodation with the aim of giving effect to the person's own decisions. So here you see from the World Network our initial advocacy for the supported decision-making paradigm that we brought into the negotiations and the drafting of the convention. We'll talk more in the segment on Article 12 about that, but we were very fortunate that the advocates of people with intellectual disabilities and their supporters had developed a very similar idea, and they used the language supported decision making, which we all it was very fortunate that these constituencies, which were the ones affected by legal capacity predominantly and by violations of legal capacity, agreed on eliminating incapacity and substitute decision making and taking this new approach. That unity in the disability community was very significant. And as you see, it was very much, as I had been starting to say, very much a framing of rights, non-discrimination based on disability, and obligations. And so we weren't talking about these are the rights of people with psychosocial disabilities. And we we had several advocacy papers where we were making it clear how people with psychosocial disabilities were impacted, how this applies to us. But it was important to use the framing of disability non-discrimination, because disability non-discrimination refers to us just as much as it refers to any other group of people with disabilities. And it was a much more positive way of appealing to the principles that UN member states would be, would find valid and persuasive. Whereas if we had simply talked about the rights of people with psychosocial disabilities, they have been so accustomed to segregating us and to seeing us as mentally ill people, as mental patients or mental health patients, that it would have been more difficult to keep the framework of equality and non-discrimination. And as we saw in the earlier document, the principles on the protection of persons with mental illness and the improvement of mental health care, there was initially a concern there was initially simply a horror, not only at some of the overt uses of psychiatry for political purposes, but also at the general um, the overall and routine human rights violations. And then psychiatrists came in and said, no, wait a minute, we can't stop all these forced interventions, we have to keep doing them. So we wanted to make sure that nothing like that was going to happen in this process, and positioning ourselves as a disability constituency, as a disabled people's organization, where there was this commitment by government to at least try to understand and work from a perspective that people with disabilities have the same rights as everyone else, and an understanding from some earlier advocacy done by the disability community that people with disabilities are the experts in our own lives. The principle, nothing about us without us, all of that, and positioning the World Network of Users and Survivors of Psychiatry squarely within the disability constituency, both in the way we framed the issue substantively and in our very full and leading participation in the International Disability Caucus. All of that really made a significant difference in our ability to ultimately have the text of the convention accept and uphold our rights that are important to people with psychosocial disabilities, state obligations that are important to us in the areas I've been describing. And even though there was some instances where we had to make very we had to make decisions about language being used. If an obligation was going to be presented in a stronger way or in a way that was less strong, so long as it gave us a legal basis to argue that the convention actually is protecting this right, that the convention, for instance, is protecting our right to liberty on an equal basis with others, that it is not in any way permitting forced institutionalization or forced hospitalization, that it is actually prohibiting that practice, and that the understanding of the states parties negotiating is that it is prohibiting that practice. That based on the plain meaning of the text and the agreements being made, and how we understood the way interpretation of a treaty works, those are the kinds of choices that we ended up having to make. And there is nothing in the convention that legitimizes the removal or restriction of our rights or any form of discrimination. And there's quite a lot that requires states parties to uphold our rights in the areas that I've been describing. So what's been happening since the adoption of the convention? There was an attempt to put in a footnote on Article 12 that would have narrowly defined legal capacity in some languages to mean capacity for rights and not capacity to act, and that would have been absolutely contrary to the entire purpose of recognizing the right to legal capacity for people with disabilities. We ended up being able to turn that around because the principle of non-discrimination was so strong, and because we had the solidarity of the disability community. The entire disability community was working with their governments to make sure that the footnote got removed, which it did. And that process actually called attention and highlighted Article 12 and legal capacity as one of the most significant rights in the convention. That became another kind of turning point, and people started to refer to the paradigm shift from substitute decision-making to supported decision-making. There's many other ways that the convention makes a paradigm shift, and we will be talking about them as we go along. The CRPD immediately did start to have an influence on other UN mechanisms. The Office of the High Commissioner for Human Rights held a meeting in 2007 aimed at presenting issues to the Special Rapporteur on Torture. I participated in that meeting, and in 2008, the Special Rapporteur, Manfred Novak, issued a report in which it was recognized that forced psychiatric interventions could amount to torture and ill treatment, and using the language that we had developed on forced interventions, he adapted it a little differently. Forced or non-consensual treatment aimed at correcting or alleviating a disability could amount to torture or ill treatment. So it immediately started to have influence on other UN mechanisms, and then there were interpretations made by the CRPD committee. We already referred to General Comment Number 1 on Article 12. Another important one is the guidelines on Article 14 that we will go into more when we discuss Article 14. I believe it's segment number 4. So clearly states parties, academia, non-governmental organizations have all been getting involved. It's very crucial, in my view, that DPOs, particularly organizations of people with psychosocial disabilities, users and survivors of psychiatry, continue to lead the process of implementation and monitoring and ongoing development of the standards at the international level, at national level, at regional level. And there's quite a lot of good work being done. I would note that the African Union has under consideration now a draft protocol on the rights of persons with disabilities that represents excellent work, and that I credit the members of the Pan-African Network of People with Psychosocial Disabilities and all of their allies. So I think there's quite a lot of good work being done, and we need to recognize that, and that user survivor organizations themselves need to understand and keep advocating for the leading role that they are entitled to have in relation to our own rights. Just one, I didn't mention Article 4.3 of the convention, that some of you probably already know what it is when I say Article 4.3, and that is, it's coming up now, just loading. Well, it's taking a long time. Okay, no, that's not the committee. That's the convention. Okay, so Article 4, Paragraph 3. Where are you? Why is it not coming? Well, it's not coming. Right, I will take it here then. And if you're not yet familiar with it, Article 4.3 says, in the development and implementation of legislation and policies to implement the present convention and in other decision-making processes concerning issues relating to persons with disabilities, states parties shall closely consult with and actively involve persons with disabilities, including children with disabilities, through their representative organizations. So that is a way of institutionalizing as an obligation under the convention itself the process and the manner in which the CRPD was actually drafted and negotiated, that people with disabilities, and particularly our representative organizations, meaning organizations representing people with disabilities, organizations of people with disabilities, because people with disabilities are entitled to represent ourselves and not have others speaking for us, that they have an obligation to closely consult and actively involve people with disabilities through our representative organizations, and children with disabilities through organizations of and representing children with disabilities. So, all of our representative organizations need to be considered and need to be included, and organizations of people with psychosocial disabilities need to be included on an equal basis with others. I see a question, can a survivor group self-nominate? I think depending on which country you're in and what kind of process they have, there may be different things you need to do in order to ensure that the government is consulting you. Some governments may not really even recognize a principle that the affected group of people has a particular right to be consulted. In some countries, there's a disability federation that the government recognizes, and yet it's possible that people with psychosocial disabilities have not been included in that disability federation. You know, there might be a family group or a mental health service provider group that is occupying that space in the disability federation, and then it can be difficult to advocate to secure your representation. I think from a human rights point of view, from an advocacy perspective, in that situation, I would probably want to say that the group has a right to be consulted, even though the Disability Federation is essentially discriminating against them. I think it's also it becomes a little more difficult if you have national organizations that are being consulted, but maybe there's no national survivor organization. I think then I would want to argue that, okay, there's no national organization, but we are an organization of people with disabilities. We have an interest. We have to be consulted. Um, and that if there are multiple organizations, but no single organization that represents, that's accepted by the constituency, then the organizations really will be in a position that they will have to work together in some way if they are, you know, if you want the government to recognize you and you're not actually advocating altogether, the government is going to find it easy to say, well, we don't really know what to do, so we won't do anything, or, you know, we will just decide ourselves. So I hope that answers the question. And under the way that the Committee on the Rights of Persons with Disabilities treats DPOs, the committee will generally, the committee gives priority to DPOs. And in that sense, absolutely, every survivor group is a DPO, you know, in the eyes of the CRPD committee. And sometimes there are issues if there's a coalition of DPOs coming from your country to participate in the country review, and you're not part of it, but you've also done a shadow report, you also want to participate, you still absolutely have a right to speak in the NGO briefing and to participate as an equal with any other NGOs. And it's always better if you can work with whatever DPO coalition or disability federation. It's always better because then you have an even greater platform of unity. You can cooperate together. But even if it isn't possible to work with the rest of the disability community in your country, you still have a right to this close consultation under Article 4.3, and you have a right in the work of the committee to be treated as a DPO. So we have about 15 minutes left, and I have reached the end of the slides. I'd like to open it up for questions and discussion. And if people, it's up to you if you would prefer to do it in the chat or to you know, to speak in the audio. So if anyone has questions or comments and, you know, you would like to bring them up, please go ahead. I hear a thank you. You're welcome. Are there any other kinds of comments? I'm just wondering if there's, maybe I can just go to the website I think you've all been exploring the website, and you see the materials for for this course. You see the materials for this segment. I put an asterisk on the materials that I consider essential. That's really a guide for you, because there's many resources that can be useful for each of the segments, and there are certain ones that I really would especially like to draw your attention to, and so those are the ones I've put an asterisk on. And you see the assignment for this is pretty simple: one-page reflection on any of the topics raised in the readings and or in the lecture. And it would also help me to know, if you want to say whether you're new or whether human rights and the CRPD are new to you, what level of knowledge you have, if you're an advocate, if you're a lawyer, if you're a person with psychosocial disability, or a user or survivor of psychiatry just getting involved in this. Okay, so I see another question. Is the state legally bound to follow the definition of disability adopted by the convention once they have ratified it? A couple of aspects to that. The state is legally bound in international law to follow all the obligations it has undertaken under the convention. So there's two aspects of that. There's how it's treated as a matter of international law, and how the state treats their international human rights obligations within the domestic law. So some states, for instance, many Latin American states, will automatically incorporate their international human rights treaty obligations as part of their domestic law, which would mean that, for instance, a person should be able to go into court and have the claim that their rights are being violated under the convention, and even if the government has not done anything else within their domestic law to put the convention into practice, the court would be able to say, yes, your rights are being violated. Now, has the CRPD adopted a definition of disability? You will not actually see a definition of disability in the convention. You see in Article 2 definitions, disability isn't there. Discrimination on the basis of disability is. In Article 1 purpose, it says persons with disabilities include those who have long-term physical, mental, intellectual, or sensory impairments, which in interaction with various barriers may hinder their full and effective participation in society on an equal basis with others. So it doesn't say persons with disabilities are, it doesn't say persons with disabilities means, it says persons with disabilities include. That's because the negotiating parties and the NGOs that were participating did not want to make an exhaustive definition of who is included among persons with disabilities. There might be something that's unforeseen now that people may not have the sense that, say, I don't know. I'm not sure how to think about what might not be included in that. But for instance, the the concept of long-term impairments, that's not necessarily well thought out, because I mean, it's not. What I'm saying is that there's people with disabilities who may have impairments that are temporary, but continue to have an effect on the person afterwards, or where a person experiences intermittent impairment or intermittent difficulties. That is very much the case for people with psychosocial disabilities. Also, when, yeah, I think this probably requires a little bit more attention and thought to really, to really elaborate on what is psychosocial disability. I may have, in the materials for the course, I may have shared something that's a link on WNUSP's. I'm going to just write it here as a reminder to myself on psychosocial disability. WNUSP's approach to psychosocial disability, I think essentially it's important to understand that the definition, that what is said about persons with disabilities in Article 1, what the committee has said is binding on states, is that they have to adopt a social model approach to disability. It's not acceptable if they define people with disabilities simply by making a list of impairments. They have to adopt a comprehensive and social model approach that acknowledges the social dimension of disability as barriers that people experience. I would say that people with psychosocial disabilities, um, for people with psychosocial disabilities, the barriers are often legal, and they often come into play at a point when it's not at all clear if the person actually has an impairment, or if it's only that other people think they have an impairment, or if any difficulty or condition they're experiencing is going to be long term. And even here, I'm using the term impairment in a much broader sense when I'm talking about psychosocial disability than what it would usually mean. And I'm using it as a kind of shorthand that I'm not really comfortable with, and I know many of you aren't comfortable with either. So let's see what Jillian is calling attention to Preamble E. Thank you. Recognizing that disability is an evolving concept and that disability results from the interaction between persons with impairment and attitudinal and environmental barriers that hinders their full and effective participation in society on an equal basis with others. And yeah, I think it's really that concept that is what the CRPD committee is always encouraging states to implement. When the CRPD criticizes a state for having an outdated approach to the definition of disability, this is, take a look at Preamble E and that paragraph in Article 1 in terms of understanding what they should be doing. Also, the committee has, also, I would say it would be in contradiction to their obligations if they're excluding people with psychosocial disabilities, because we are included in the term, even if we hate that way of referring to it, mental people who have impairments, which in interaction with various barriers, etc. And this notion that it has to be long term doesn't necessarily apply to us. It doesn't necessarily apply to all the obligations. In relation to many obligations, including Article 14, liberty and security of the person, the committee has consistently referred to people having actual or perceived disabilities or actual or perceived impairments. And so that really throws this concept of long-term impairment out the window, because it recognizes that this discrimination can be happening to us because other people are attributing something to us that we may not identify with, even if we might be experiencing something that we identify ourselves as a disability. Or even if we're just not experiencing anything of the kind, but we're being reacted to with serious discrimination that hinders our full and effective participation. So I would invite you, if you're interested in exploring that, it would be interesting to if any of you want to take that as something to reflect on in this paper or in discussions that we could have on the email list. There was another question: how can DPOs influence states to ratify if they haven't done so as yet? There's always campaigns going on in different countries. I think one of you pointed out before, Canada was working on accession to the optional protocol, and when a country has ratified one but not the other, there's often an ongoing campaign by DPOs to get them to ratify the protocol. In a country like the US, there's been a campaign to have our Senate ratify the convention. And it depends a lot on the overall political circumstances going on in the country, on general approaches to friendliness versus hostility to international human rights treaties, the different political forces involved. And I think for some obvious reasons in relation to the United States right now, where it's highly unlikely that we're going to see the ratification of the convention anytime in the next 4 years or so, given our current president and Congress, the political makeup. But I would also say that even if your country has not ratified the CRPD, there's a lot you can do to work on advocating the standards. So even in the United States, there was a judge in, I think it may have been 2008. It was before the CRPD committee had started to work or issue any concluding observations. But this judge was a judge in the surrogates court, which deals with some cases on legal capacity and guardianship, and she took on the standards, some part of the standards promoted in Article 12, and brought that up as an indication that the International Human Rights Committee is saying that we have to do better, and we have to allow for supported decision making. We can't simply say substitute decision making is the only alternative. And in the US also, there are some cities, towns, and also some of the individual states in our federal jurisdiction that decide that they're going to adopt the obligations in an international human rights treaty and hold themselves accountable for complying or for upholding or fulfilling or realizing those human rights. And so there's many different ways that people can still be promoting adherence to the standards, even if it's not legally binding on their government. And another way is by appealing to other international human rights mechanisms that are upholding the CRPD, some other human rights treaty bodies. The Committee on Elimination of Discrimination Against Women, for instance, has issued some concluding observations, say to end forced hospitalization and institutionalization of women, and that sort of thing. The Special Rapporteur on the Rights of Persons with Disabilities, the Working Group on Arbitrary Detention, those are human rights mechanisms you can appeal to even if your state has not ratified any human rights treaties. So that's a long answer to an aspect of the question that wasn't necessarily addressed. A lot of those materials are linked on that the general page of the course website. And I think since here, this is the general materials page, if there's anything that you're interested in that you don't find, please just ask and I'll try to remember to provide all necessary information. So since we're at the end, I'm going to close, and I will invite you um, to continue having a discussion in the email group. Raise any comments or questions you want to have. Feel free to answer one another's questions, comment on one another's questions or comments as much as you like. And I look forward to receiving your assignments and to the rest of the course. Thank you all, and goodbye.